Before we begin, a quick and important disclaimer. The following content is provided strictly for educational, historical, and entertainment purposes. It does not constitute legal advice, financial counsel, or professional guidance for modern matrimonial proceedings. Laws and social standards have evolved significantly since the 1800s, and any historical trends or case studies discussed herein are intended to provide context on the past, not instructions for the present. Viewers are strongly encouraged to conduct their own due diligence and consult with qualified legal professionals regarding contemporary family law matters. In 1860, a man living in the state of New York who found himself trapped in a miserable marriage had almost no way out, unless he could prove with eyewitness testimony that his wife had committed the ultimate sin of adultery. He was legally bound to her until the day he died. If he tried to leave without a court order, he was a deserter. If he took up with another woman, he was a criminal. In the eyes of the Victorian public, a man who could not manage his own household was not just a failure as a husband. He was a failure as a citizen. Yet, during this same era, thousands of men were quietly boarding trains to remote frontier towns in Indiana and South Dakota, seeking a legal cure for their domestic misery that was unavailable in the prestigious halls of East Coast justice. We often think of the 19th century as an era of rigid, unbreakable family bonds, but the reality was a high-stakes legal chess match where one wrong move could cost a man his property, his children, and his social standing. Today we are performing a deep dive into the hidden world of 19th century divorce, uncovering the specific strategies, legal loopholes, and social maneuvers men used to navigate a system designed to keep them married at all costs. This is not a surface-level history. This is a masterclass in the evolution of American family law and the specific historical trends that shape the modern masculine experience in the courtroom. By the end of this deep dive series, you will understand exactly how the power dynamics of the American household shifted from the total legal dominance of the early 1800s to the complex, often contentious litigation of the late Victorian era. We will explore why certain states became divorce colonies, how men navigated the transition from the doctrine of coverture to the rise of women's property rights, and the specific case studies that show how historical figures successfully and unsuccessfully sought their freedom. This information solves a critical problem for the modern observer. It provides the why behind our current legal system. You cannot understand today's alimony, custody, or property division laws without understanding the 19th century battlegrounds where these concepts were first forged in the fires of social scandal. To understand the help available to a man in the 19th century, one must first understand the crushing weight of the legal doctrine known as coverture. Under English common law, which dictated most American legal thought in the early 1800s, a husband and wife were considered a single legal entity. That entity was the husband. Upon marriage, a woman's legal existence was effectively suspended or covered by her husband. This meant that, technically, a man could not divorce his wife easily because he would effectively be suing a part of himself. However, this also meant he held the title to all property, all wages earned by the wife, and absolute custody of all children. In the early part of the century, help for a man usually meant asserting these absolute rights to force a domestic resolution. But as the century progressed, the social contract began to fray. A man seeking a divorce in 1840 faced a bifurcated system. There was divorce mensa thura, which translated to from bed and board. This was essentially a legal separation. The parties lived apart, but they were still technically married and could not remarry. This was often the only option in states like South Carolina, which for a significant portion of the century, did not allow absolute divorce under any circumstances. For a man of means, this was a purgatory that prevented him from producing a legitimate heir with a new partner. The alternative was divorce a vinculo matrimoniae, or from the bond of marriage, a total dissolution that allowed for remarriage. Achieving this required navigating a maze of fault-based statutes. In this era, there was no such thing as a no-fault divorce. To get out, someone had to be the villain. For a man to successfully petition the court, he had to prove his wife had committed a specific statutory offense. These typically included adultery, desertion, usually for a period of 2 to 5 years, or extreme cruelty. However, the definition of cruelty was heavily gendered. While a woman could sometimes claim cruelty if her husband was physically violent, a man often had to prove intolerable indignity or behavior that made his life burdensome. Historical trends show that men often relied on the desertion plea, as it was the least scandalous way to end a marriage, though it required the husband to wait years while his life remained in limbo. One of the most fascinating help mechanisms for men in this period was the legislative divorce. Before the mid-19th century, many divorces weren't handled by judges at all, but by state legislatures. A man would have to hire a lobbyist or a well-connected lawyer to present a private bill to the state assembly. Imagine the high-stakes pressure of having your private marital failures debated by politicians and published in public records, just to get a decree. This was a process reserved for the elite, the wealthy, and the politically connected. It was a demonstration of the potential outcomes for those with high social capital, while the common man was often left with informal divorce, simply walking away and moving to a different state to start a new life under a different name, a practice so common it became a defining feature of the American frontier. As we move deeper into the mid-century, we see the rise of the Great Divorce Mills. This is where the tactical help for men truly evolved. States like Indiana realized that by shortening residency requirements and broadening the grounds for divorce, they could attract tourists from the strict East Coast. A man from New York, where adultery was the only ground for divorce, could travel to Indianapolis, stay for a few months to establish residency, and claim habitual drunkenness or mental cruelty to secure a quick decree. This created a massive legal industry. Lawyers in these divorce colonies specialized in helping men manufacture the necessary residency evidence. This historical trend highlights the first major tension between state jurisdictions in the U.S., as New York courts often refused to recognize these Western divorces, leading to high-profile bigamy trials when men remarried based on Indiana decrees. Furthermore, a man in the 19th century had to navigate the doctrine of recrimination. This was the ultimate gotcha in the legal system. If a man sued his wife for adultery, but she could prove that he had also been unfaithful, or even that he had been slightly cruel, the court would dismiss the case entirely. The law dictated that only an innocent and injured party could receive relief. If both were at fault, the law left them as it found them, trapped together in a permanent state of legal warfare. This led to the rise of early private investigators and shams, where parties would collude to hide each other's faults just to get the judge to sign off on the papers. A risky maneuver that, if caught, could lead to charges of collusion and a lifetime of forced marriage. Understanding these mechanics is essential because they represent the origin of the adversarial nature of family law. The help available to men was often a double-edged sword. It required a public airing of grievances that could destroy a man's professional reputation in an era where character was the primary currency of business. As we continue this deep dive, we will look at the specific financial costs of these actions, the tender years doctrine, which began to strip men of their absolute custody rights, and the step-by-step process used by 19th century lawyers to navigate the increasingly complex web of Victorian morality and emerging statutory law. This was an era of transition, where the old world of patriarchal dominance met the new world of individual rights, and for the men caught in the middle, the courtroom was a place of extreme peril and hard-won freedom. To understand the help available to a man in the 19th century, one must first confront the terrifying financial reality of the courtroom. Imagine if you are John Smith, a successful merchant in Philadelphia in the year 1875. You've built a respectable life, your business is thriving, and your social standing is impeccable. But behind closed doors, your marriage has disintegrated into a battlefield of resentment. In 2026, you might expect a relatively clean mediation process, but in the 1870s, your first encounter with the legal system would be a financial shock known as suit money. Because the legal doctrine of coverture effectively stripped a wife of her independent financial identity, the law dictated that the husband was responsible for her legal fees. This meant that if John Smith wanted to sue for divorce, or if his wife sued him, he was legally mandated to pay for two sets of lawyers, his own and hers. This was not a small administrative fee. This was often an open-ended liability. Historical trends show that judges would frequently order a husband to pay alimony pendant light, which is Latin for support during the litigation. From the moment the first papers were filed until the final decree was signed, John Smith would be forced to pay a weekly or monthly sum to maintain his wife in the lifestyle to which he had become accustomed, regardless of whether she was the one who had committed an offense like desertion or adultery. This created a massive incentive for a wife's legal team to prolong the case. For a man in the 19th century, the legal help he sought often began with a desperate attempt to limit this financial hemorrhaging. A man's lawyer would have to argue aggressively that the wife had independent means or that his own business was on the verge of collapse just to keep from being drained dry before the trial even began. Case studies from this era reveal the extreme lengths men went to in order to protect their assets. In 1882, a prominent businessman in New York found himself facing a divorce petition from a wife who claimed extreme cruelty. Under the laws of the time, the court could grant her permanent alimony, which was essentially a lifetime pension paid out of his earnings. To counter this, the husband's strategy wasn't just to defend his character, but to prove a countercharge of adultery. Why? Because in many jurisdictions, if a wife was proven to be an adulteress, she forfeited her right to alimony. This turned the courtroom into a detective novel. Men would hire early versions of private investigators, known then as shadowing agents, to follow their wives to parks, theaters, and boarding houses, looking for a single moment of indiscretion. They weren't looking for a confession, they were looking for opportunity and inclination. If they could prove she was in a private room with another man and that they had shown affection in public, that was often enough to save the husband from a lifetime of alimony payments. However, the 19th century man faced a double-edged sword, known as the double standard of morality. While a man could lose his fortune if his wife proved his infidelity, the social cost for the man was often managed differently than for the woman. Yet the legal costs remained high. If a man like our fictional John Smith was found guilty of adultery, he didn't just lose his marriage. He often lost his right to ever marry again in that state. In New York, for instance, the guilty party in a divorce was legally prohibited from remarrying during the lifetime of the innocent party. For a man in his prime who wanted to start a new family and secure his legacy, this was a legal death sentence. Help for a man in this situation often meant crossing state lines. This is where we see the historical trend of the Reno divorce or the Indiana loophole taking root. A man would take a business trip to a more lenient state, establish a sham residency for 6 months, and secure a divorce that his home state might not even recognize. The step-by-step process of securing one of these migratory divorces was a masterclass in legal maneuvering. Step 1 was establishing a domicile. This wasn't just checking into a hotel. It meant renting a house, opening a local bank account, and perhaps even joining a local fraternal organization like the Masons or the Oddfellows to prove he intended to stay. Step 2 was the notification. To avoid his wife finding out and filing an injunction in their home state, the man would often publish the divorce notice in a small, obscure local newspaper that he knew she would never see. If she didn't show up to contest it, the judge would grant a default judgment. This was the secret weapon for many 19th century men, but it carried a massive risk. If he returned home and tried to remarry, his first wife could sue for bigamy, potentially sending him to prison and delegitimizing any children from his second marriage. Beyond the financial and legal mechanics, there was the crushing weight of social reputation. In the 1800s, a man's credit was his character. Banks didn't just look at your ledger, they looked at your life. A man involved in a scandalous divorce was seen as a man who could not manage his own household, which suggested he could not be trusted to manage a loan or a partnership. We see this in the case studies of the 1887 Department of Labor Report on Marriage and Divorce, the first of its kind in the United States. The data showed that while divorce rates were skyrocketing, the vast majority of men were still terrified of the public trial. This led to a rise in informal separations by agreement. A man would provide his wife with a lump sum of cash or a specific piece of property in exchange for her moving to a different town and never using his name again. It was a private contract designed to bypass the public court system entirely. This was help in its most pragmatic, if legally gray, form. But what happened when the conflict moved from the checkbook to the nursery? For the first half of the century, a man had an almost absolute right to his children. They were seen as his property and his responsibility. But by the 1870s and 80s, a seismic shift was occurring in American courtrooms. The rise of the tender years doctrine began to suggest that children, especially young ones, belonged with their mothers. For a man like John Smith, this was a terrifying evolution. He could find himself in a position where he was paying for a household he no longer lived in, paying for a lawyer who was attacking his character, and now losing the very heirs he had worked his entire life to provide for. The help a man needed was no longer just about property. It was about the very definition of fatherhood in a changing world. As the 19th century drew to a close, the battle for the American family was becoming more intense, not less. The legal strategies were becoming more sophisticated, and the stakes were moving beyond mere money. The next great hurdle for any man seeking a divorce wasn't just the judge or the bank. It was the fight for his own children in a system that was starting to view him as an optional part of the domestic circle. But how did men fight back against the tender years doctrine? What specific legal arguments did they use to prove a mother was unfit? in an era where women were put on a moral pedestal. And what happened when a man's own habitual intemperance, or failure to provide, was turned against him in a court of law? We are about to dive into the high-stakes world of 19th century custody battles, where the definition of a good father was being rewritten in real time. To understand the high-stakes battle for children in the 19th century, you have to realize that for centuries, the legal system operated under the principle of paternal preference. In the early 1800s, if a marriage dissolved, the children were viewed almost as a form of property or labor belonging to the father. He was the one with the legal standing, the one with the property, and the one responsible for their spiritual and professional upbringing. But as we move into the middle and late 19th century, a radical shift occurred that caught many men off guard. This was the rise of the tender years doctrine. Imagine if you are John Smith in the year 2026, looking back at your great-great-grandfather's legal battle in 1880. He likely entered the courtroom expecting his traditional rights to be upheld, only to find that the judge was now prioritizing the emotional bond between a mother and her young children over the father's historical dominance. This shift was not an overnight change, but a gradual historical trend that fundamentally altered the help a man needed in a custody dispute. The tender years doctrine suggested that for children under the age of 7, the mother was the naturally superior caregiver. For a man seeking to maintain his relationship with his children, this was a legal wall that required a specific, often aggressive strategy to dismantle. If you were a man in 1885, your legal counsel wouldn't just argue that you were a good provider, they would have to engage in what we now call character assassination. To bypass the tender years preference, a father had to prove that the mother was morally unfit to a degree that outweighed the biological assumption of her care. Case studies from this era show that the definition of unfitness was strictly tied to the Victorian cult of domesticity. A man's best chance at winning custody often involved proving that his wife had violated one of the 4 pillars of womanhood: piety, purity, domesticity, or obedience. If a husband could produce witnesses, neighbors, domestic servants, or even the wife's own family, to testify that she read sensationalist novels instead of the Bible, or that she frequently attended the theater without him, he could build a case for moral neglect. In one 1878 case in Ohio, a father successfully gained custody of his 5-year-old daughter not by proving he was a better parent, but by proving that the mother was a member of a spiritualist group. The court ruled that her belief in communicating with the dead was evidence of an unstable mind that would corrupt the child's moral development. The step-by-step process for a man fighting this battle was grueling. Step 1 was usually a writ of habeas corpus. In the 19th century, this wasn't just for prisoners. It was the standard legal tool. A father used to demand that a mother produce the children in court. Because the father technically held the legal right to the children, a mother who took the children and left the home was often viewed as withholding them. Once in court, the burden of proof began to shift. The man had to demonstrate his ability to provide a suitable substitute for maternal care. Since he was expected to be out of the house working, he couldn't claim he would do the caretaking himself. Instead, he would bring in his mother, an unmarried sister, or a high-status governess to testify. He was essentially telling the judge, "I have the financial means to provide a better, more stable female influence than this wayward mother can provide." Historical trends during the 1880s and 1890s show that men were increasingly using the economic stability argument as a counterweight to the maternal bond. While the court was starting to value the mother's love, it still deeply valued a child's social and financial future. A man who could show that he could provide a private education, a respectable home in a clean neighborhood, and a future inheritance held a significant advantage. Imagine a scenario where a mother wanted to move the children to a cramped apartment in a growing industrial city, like Chicago, to work in a garment factory. The father's lawyer would argue that this was a form of environmental cruelty, claiming the children's health and social standing would be permanently damaged by the mother's poverty. In the eyes of many 19th century judges, a father's checkbook was often seen as a more reliable guardian of a child's future than a mother's affection. However, this created a massive financial trap for men. Even if a man lost custody, he was rarely relieved of the financial burden. This era saw the beginning of what we now recognize as child support, though it was rarely called that. Instead, it was often framed as the father's continuing duty to provide. A man could find himself banned from seeing his children because the court found his temperament unsuitable, yet still be ordered to pay for their clothing, schooling, and medical care. To fight this, men often used a strategy of conditional support. They would offer to pay for the children's expenses only if the children were placed in a boarding school or with a neutral third party, effectively trying to buy the children away from the mother's daily influence. Another critical piece of help for men in this era was the use of the children's own testimony, provided they were old enough. Unlike today, where children are often shielded from the courtroom, 19th century judges would often interview children as young as 9 or 10 to determine their preference. But this wasn't about the child's happiness. It was about their moral alignment. A father who had spent years cultivating a relationship based on shared professional interests or intellectual pursuits with a son could often sway a judge. The argument was that a boy needed the firm hand of a father to transition into a productive citizen. Historical data indicates that while mothers began to win custody of daughters more frequently, fathers still maintained a very high success rate in keeping custody of their sons, especially once the boys reached the age of 12. But if the man was the one being accused? In the late 1800s, the temperance movement was at its height, and a man's habitual intemperance, or drinking, became the #1 weapon used against him in custody and divorce cases. A single public incident of intoxication could be enough for a judge to declare a man unfit. The help available to men in this position was often a desperate Reformation defense. A man would join a temperance society, take a public vow of sobriety, and bring in his employer to testify to his reliability at work. This was a high-stakes game of public performance. If he could prove he was a sober and industrious man, he could often neutralize his wife's claims of cruelty or neglect. The complexity of these battles cannot be overstated. We are looking at a period where the very foundations of the American family were being litigated in real time. Men were forced to navigate a system that was moving away from the cold logic of property rights and toward the subjective, emotional landscape of the best interests of the child. This transition created a void of uncertainty that only the most prepared and financially liquid men could navigate. As we move forward, we have to look at the other side of this legal coin. If the children were the emotional stakes, the property was the physical survival. How did a man protect his land, his business, and his wages in an era where married women's property acts were being passed in almost every state? What happened when a man's wife, who previously had no legal right to own a spoon, suddenly had the power to sue him for half of his estate? The next phase of our masterclass dives into the financial shield, the specific, often cutthroat tactics men use to hide assets, undervalue businesses, and navigate the first wave of modern property division. You think today's asset protection is complex? You haven't seen anything until you've seen a 19th century industrialist try to disappear a railroad company before his wife's lawyer could get a subpoena. The battle for the bank account was about to get very, very dirty. The financial landscape for a man in the late 19th century was undergoing a seismic shift that most were completely unprepared to handle. To understand the help a man needed then, you have to realize that for the first half of the century, the law was essentially on his side by default. Under the old rules of coverture, a wife's legal identity was merged into her husband's. Her dowry, her inherited land, and even the wages she earned working in a textile mill belonged legally to him. But by the 1870s and 1880s, the passage of Married Women's Property Acts across the United States turned this world upside down. Imagine if you are Robert Harrison, a factory owner in Chicago in 1890. In the year 2026, you might worry about digital assets and offshore accounts, but for Robert, the threat was much more tangible. Suddenly, the land his wife brought into the marriage, land he had built his factory on, was no longer legally his. If she sued for divorce, she could take the ground right out from under his machinery. This created a massive demand for a new kind of legal help, the art of asset protection in a transitionary era. Historical trends show that as women gained the right to own property independently, men began to utilize increasingly complex methods to shield their wealth. One of the most common potential outcomes of a high-stakes divorce was the total liquidation of a man's liquid capital before the first court date. A man in Robert Harrison's position would be advised by his counsel to move his wealth into bearer bonds or physical gold, assets that didn't have a paper trail in an era before centralized banking and digital ledgers. The step-by-step process for a 19th century man to shield his business often began with the straw man transaction. Step 1 involved identifying a trusted male relative or a business partner who was not currently involved in legal turmoil. Step 2 was the sale of the business or property to this individual for a nominal fee, often just $1. Step 3 involved a private, unrecorded contract stating that the property would be sold back to the original owner once the divorce decree was finalized. This was a high-risk maneuver. If the trusted partner decided to keep the property, the husband had no legal recourse because he had essentially admitted to a fraudulent transfer. Yet, case studies from the 1880s suggest that this was a frequent occurrence among the merchant class who saw their entire life's work at risk of being carved up by a newly empowered probate court. Beyond simple transfers, men had to navigate the rise of alimony as a permanent financial drain. In the early 1800s, alimony was rare because women rarely divorced. But by 1890, the U.S. had the highest divorce rate in the Western world, and judges were increasingly using alimony to ensure that a divorced woman did not become a burden on the state. For a man, the help he needed was a financial defense of necessity. His lawyer would spend weeks auditing his own clients' books to make the business look as unprofitable as possible. They would purposefully delay collecting debts, overstate the cost of raw materials, and claim massive personal liabilities. The goal was to prove to the judge that while the man appeared wealthy, his actual cash flow was so precarious that a high alimony award would bankrupt the company and put dozens of men out of work. In an era that idolized industrial growth, the threat of closing a factory was a powerful lever in the courtroom. Another fascinating historical trend was the use of the spendthrift trust. While these are common in 2026 for estate planning, in the 19th century, wealthy fathers began setting them up for their sons as a preemptive strike against future daughters-in-law. If a man's wealth was held in a trust controlled by his own father or a third-party trustee, it was technically not his property and therefore could not be touched in a divorce settlement. This led to a strange social dynamic where grown, successful men were legally treated like minors who received a stipend from their family estate, all to ensure that the family fortune remained intact if the marriage dissolved. The battle for the bank account also extended to the concept of the wife's separate estate. This was a specific legal loophole where a man's lawyer would try to prove that the wife had already received her fair share of the marital wealth through jewelry, clothing, or previous gifts of cash. If a husband could produce receipts showing he had spent thousands of dollars on his wife's wardrobe and social life, he could argue that these were advancements on any future settlement. Case studies from the New York social scene in the 1890s show husbands meticulously keeping records of every diamond necklace and every imported silk dress, not as a sign of affection, but as a legal ledger to be used in the event of a courtroom battle. However, the most desperate form of help for a man facing financial ruin was the absconding husband strategy. This wasn't a legal strategy so much as a total rejection of the system. A man would sell what he could, take the cash, and disappear into the Western territories. Because there was no national tracking system, no social security numbers, and no way to garnish wages across state lines in the 1880s, a man who made it to the frontier was effectively untouchable. This created a massive social crisis of abandoned wives. But for the man involved, it was a way to reset his life and protect his future earnings from a court system he viewed as increasingly hostile to his interests. As we look at the data from the 1887 Department of Labor report, we see a clear correlation between the rise of women's property rights and the increase in fraudulent property transfers by men. The legal help of the era was effectively teaching men how to navigate a system that was moving from the absolute clarity of "the husband owns everything" to the murky, subjective world of equitable distribution. This transition was messy, expensive, and deeply personal. It turned every marriage into a potential partnership agreement that could be audited at any moment. But while the money was a massive point of contention, it was often just a proxy for the deeper battle of social survival. In the 19th century, a man's credit was tied to his reputation, and a divorce trial was the ultimate reputation killer. The next great challenge for a man wasn't just hiding his gold. It was silencing the scandal. How did men use the private referee system to keep their dirty laundry out of the newspapers? What happened when yellow journalism turned a private financial dispute into a public spectacle that could ruin a man's business prospects forever? We are about to enter the world of the Victorian media blackout, the specific tactics men used to buy silence, influence editors, and keep the most scandalous details of their domestic lives from becoming the talk of the town. The price of privacy was often higher than the price of the divorce itself, and for the men of the 1890s, the battle for the front page was just beginning. In the 1890s, the greatest threat to a man seeking a divorce wasn't just the judge or the financial settlement. It was the printing press. This was the era of yellow journalism, where sensationalism sold more papers than the truth, and a high-profile divorce was the ultimate fuel for the circulation wars. Imagine if you are Samuel Harrison, a prominent shipping magnate in 1895. In the year 2026, you might worry about a viral post or a leaked video, But for Samuel, the threat was the daily newspaper being delivered to the doorstep of every business associate, every creditor, and every member of his exclusive social club. A single headline detailing his domestic failures could trigger a run on his company's stock, or lead to the immediate cancellation of his credit lines. For the 19th century man, the help he needed most was a legal and social blackout. The first line of defense in this battle for privacy was the private referee system. This was a specific legal loophole available in several states, most notably New York, that allowed wealthy individuals to move their divorce proceedings out of the public courtroom and into a private office. Instead of a judge, the case would be heard by a court-appointed referee, often a fellow lawyer or a retired judge. The potential outcomes of this strategy were immense. By paying for the referee's time and the use of a private space, a man could ensure that the testimony, no matter how scandalous, was never heard by the public or the hovering reporters from the gossip rags. The step-by-step process involved a joint motion by both parties' lawyers to refer the case to a private hearing, ostensibly to save the court's time, but in reality to seal the record. Case studies from the Gilded Age show that this was the preferred method for the American aristocracy. In one 1892 case, a railroad heir managed to have 3 weeks of testimony regarding his alleged desertion and financial misconduct heard in a private law office. Because the proceedings were not in a public courtroom, the press had no legal right to enter. When the final decree was issued, only the result was made public, while the thousands of pages of grueling cross-examination remained under lock and key. This was the 19th century version of an ironclad non-disclosure agreement. However, this help was only available to the ultra-wealthy. For the average man, the courtroom was a fishbowl, and his only hope was to control the narrative through other means. When a private referee wasn't an option, men turned to the strategy of the friendly suit. This was a calculated legal maneuver where the husband and wife would agree on the grounds and the evidence beforehand to ensure the trial was as short and boring as possible. Historical trends show that the more sensational a trial appeared, the more likely it was to be covered. By stripping the case of any spicy details and presenting a dry, technical argument for desertion or incompatibility, in states where that was beginning to be recognized, a man could bore the reporters into leaving the room. The goal was to make the divorce look like a routine business transaction rather than a moral failing. But what happened when the wife refused to play along? If a wife decided to go to the press to leverage a better settlement, the husband's legal team would deploy the slander and libel defense. In the late 1800s, a man's reputation was a tangible asset. If a wife made public claims of cruelty or infidelity that could not be proven in court, the husband would immediately file a countersuit for slander. This wasn't necessarily about winning more money. It was about creating a legal gag order. By making the wife a defendant in a defamation case, the husband's lawyer could warn newspapers that printing her claims would make them liable for damages as well. This created a chilling effect that forced many editors to spike a story, rather than risk a costly libel battle with a man who had deep pockets. We must also look at the role of the gossip rag, most notably a publication called Town Topics. This magazine was the 19th century equivalent of a tabloid, and it specialized in blind items about the divorces of the wealthy. The help a man needed here was often more shadow work than legal work. Historical data suggests that many prominent men kept publicity agents or fixers on retainer whose sole job was to negotiate with editors. They would offer exclusive business news or tips on other scandals in exchange for keeping the employer's divorce out of the columns. This was a high-stakes game of information trading that required a man to have a vast network of influence. If he couldn't stop the story, he would try to flood the zone with counter-narratives, emphasizing his philanthropic work or his business successes to drown out the domestic noise. Imagine the pressure on a man like our fictional Samuel Harrison. He is sitting in his mahogany row office, knowing that at any moment, a process server could walk in and change his life forever. The help he seeks isn't just about the law, it's about the optics. He might be advised by his counsel to take a prolonged European vacation, just as the suit is filed. This was a classic 19th century tactic. By being physically absent from the country, the man made himself a difficult target for the press. He couldn't be cornered for a quote, he couldn't be seen looking haggard in a courtroom, and by the time he returned, the news was stale. The American public's attention span in the 1890s was short, and a man who could outwait the news cycle often emerged with his reputation relatively intact. Furthermore, we see the rise of the confidential settlement. Before a case even reached a judge, a man's lawyer would present a contract of separation. This was a private agreement that handled the division of property, and the custody of children, outside of any government oversight. The key clause in these contracts was always the silence clause. If the wife ever spoke of the reasons for the separation or the terms of the deal, she would forfeit her entire financial package. For a man, this was the ultimate form of help. It turned his financial power into a permanent muzzle. In an era where a woman had very few ways to earn a respectable living, the threat of losing her settlement kept her silent for decades. This obsession with privacy was not just about ego, it was about survival in the Victorian social hierarchy. A divorced man was a marked man, but a man who had quietly separated was often still welcomed in the drawing rooms of the elite. The distinction was entirely about how much of the dirty laundry had been aired in public. This created a two-tiered system of divorce help: the public, messy and often ruinous path for the common man, and the private, controlled and expensive path for the industrialist. The 19th century courtroom was a theater, and the most successful men were the ones who could keep the curtain from ever rising. As we move into the final years of the century, this battle for privacy would collide with a new and even more dangerous phenomenon: the rise of the professional witness. What happened when the silence couldn't be bought? What happened when a new class of divorce detectives began specializing in manufacturing evidence that couldn't be ignored by even the most sympathetic judge? The next part of our masterclass explores the dark world of 19th century espionage, where the help a man hired often turned out to be his greatest liability. We are going inside the world of the shadow agents, the wiretappers of the 1890s, and the high-stakes game of entrapment that turned the American divorce court into a literal spy thriller. The era of the private eye was born in the bedroom, and for the men of the 1890s, no door was truly locked. By the mid-1890s, the help a man sought in a divorce case had shifted from the library of a lawyer to the dark alleys of the private investigator. To understand this transition, we have to look at the professionalization of suspicion. In the early 19th century, evidence of marital misconduct was usually gathered by accident or through the loose lips of a disgruntled neighbor. But as the stakes for property and reputation grew, a new industry emerged: the matrimonial detective. Imagine if you are Thomas Miller, a wealthy industrialist in the year 2026, researching the history of your family's fortune. You might find a ledger from 1898 belonging to your great-great-grandfather that includes a massive, unexplained payment to a firm like the Pinkerton National Detective Agency. This was not for protecting a train or a factory, it was for the infiltration of his own home. The help available to a man in this era included a step-by-step system of domestic espionage that would make a modern spy blush. Step 1 was the infiltration. Because the law required physical proof of a wife's indiscretion to bypass alimony or secure custody, a husband would hire a shadow agent. This agent wouldn't just follow the wife on the street, they would often bribe the household staff. Historical trends show that the first point of contact was usually the chambermaid or the coachman. For a few silver dollars, these employees would provide a copy of the wife's social calendar, the names of all her visitors, and most importantly, the contents of her wastebasket. In an era where every communication was handwritten on paper, discarded draft of a letter was the 19th century equivalent of a leaked text message. Step 2 was the intercepted communication. While we think of wiretapping as a 20th century invention, the 19th century man had his own version: the steam-open letter. If a husband suspected his wife was corresponding with a paramour, his legal team would advise him to secure the mail before it reached her hands. Using a tea kettle to soften the wax or glue, the husband or his detective would read, transcribe, and sometimes even alter the letters before resealing them. This evidence was then presented in court as a smoking gun. However, case studies from the 1890s indicate a high risk in this strategy. If the defense could prove the letter was intercepted illegally, or that the husband had tampered with the seal, the entire case could be dismissed under the doctrine of unclean hands. Step 3 was the setup, often referred to as the trap. This is where the help a man hired could become extremely dangerous. Some agencies specialized in providing a decoy or a stool pigeon. They would hire an attractive, well-spoken man to intentionally cross paths with the wife at a park or a social function. The goal was to entice her into a situation that appeared scandalous, perhaps a private carriage ride or a visit to a tea room known for illicit trysts. The detective would be waiting nearby to jump out and produce a witness. This was a high-stakes game of entrapment. If the court found that the husband had actively encouraged his wife's infidelity just to get a divorce, he was guilty of connivance. Under the law of the time, connivance was an absolute bar to divorce. The man would be forced to stay married to the woman he had just tried to ruin, and his reputation would be permanently shattered. The role of the professional witness became a defining feature of the 1890s divorce court. These were individuals who made a living by testifying in domestic cases. Some were disgraced former police officers. Others were simply individuals with a flexible relationship with the truth. For a man seeking help, these witnesses were a double-edged sword. On one hand, they could provide the necessary third-party corroboration that the law demanded. On the other hand, they were easily discredited on cross-examination. We see this in a famous 1896 case in Philadelphia where a husband's entire case collapsed when it was revealed his star witness had testified in 12 different divorce trials in 3 different states in a single year. The judge famously remarked that the witness seemed to have a supernatural ability to be present at every adultery in the tri-state area. Another fascinating historical trend was the use of the early camera. While photography was still cumbersome by the late 1890s, detectives were using the first portable cameras to capture what they called incriminating tableaus. These weren't the high-definition photos of 2026. They were blurry, grainy images taken through keyholes or from across the street. Yet, in a courtroom that had never seen photographic evidence, the impact was psychological. The mere existence of a photo of a wife standing too close to another man could be enough to force a settlement. A man's lawyer would use these photos as a leverage tool during pretrial negotiations. The message was clear: settle now for a small fraction of the estate, or these photos will be printed in the Sunday supplement. However, the help a man hired often turned on him. This is the dark side of the 19th century detective industry. Because these agents were operating in a legal gray area, blackmail was rampant. A detective who gathered evidence of a wife's infidelity might realize that the husband had his own secrets. There are numerous case studies of shadow agents who, after finishing their job for the husband, would visit the wife and offer to lose the evidence for a secondary fee, or worse, would threaten to tell the court that the husband had coached their testimony. For a man like Thomas Miller, the very people he hired to save his fortune could become the parasites that drained it. This era also saw the rise of the medical witness as a form of help. In cases where physical indiscretion couldn't be proven, men began to lean on the emerging field of psychology, or what was then called alienism. A husband might hire a doctor to testify that his wife was suffering from hysteria or moral insanity. This was a brutal but effective tactic. If a wife could be declared mentally incompetent, the husband could not only secure a divorce on the grounds of hopeless insanity in some states, but could also gain total control over her property and the children without having to prove a single act of adultery. It was the ultimate clean break, achieved through the cold language of medical science rather than the messy theater of detectives. The 19th century man was navigating a world where the domestic sphere had become a battlefield of surveillance. Every servant was a potential spy, every letter a potential piece of evidence, and every doctor a potential executioner of his marital bonds. The help he sought was designed to give him an information advantage, but it created a culture of paranoia that eventually led to a massive public backlash. The American public was becoming disgusted with the snooping industry, and the courts were beginning to tighten the rules of evidence. But what happened when the surveillance failed? What happened when a man's wife was too smart to be trapped, too pious to be slandered, and too wealthy to be silenced? This is where the 19th century legal battle moved into its final, most extreme phase: the madhouse strategy and the weaponization of the asylum. In the next part of our masterclass, we will explore the terrifying reality of men who use the lack of mental health regulations to physically remove their wives from society altogether. We'll look at the case studies of the forced commitments of the 1890s and the specific legal hurdles a man had to jump to convince a judge that a wife's desire for a divorce was actually a symptom of a diseased mind. The battle was no longer just about the bank account or the children. It was about who got to remain a free citizen. To understand the most extreme form of help a man could seek in the late 19th century, we have to look past the courtroom and toward the high stone walls of the Victorian asylum. By the 1890s, the legal system had become so bogged down in scandals, detectives, and property disputes that some men sought a more permanent, non-judicial solution to their marital problems. This was the era of the madhouse strategy. Imagine if you are James Whittaker, a wealthy industrialist in the year 2026, looking back at the archived records of your ancestor in 1892. You might find a curious gap in the family tree where a wife simply disappears from the record, not through death or a public divorce, but through a medical certification of lunacy. For a man like the elder Whittaker, whose wife might have been demanding a divorce that would split his massive fortune and ruin his social standing. The help he needed wasn't a lawyer, it was an alienist. In the 19th century, an alienist was what we now call a psychiatrist, and they held a terrifying amount of power over the personal liberty of women. Historical trends show that as divorce laws became slightly more accessible for women, the rate of female commitment to asylum saw a corresponding and suspicious spike. The legal framework of the time allowed for what was known as non-judicial commitment. In many states, including Illinois and New York for a significant portion of the century, a man did not need a judge or a jury to have his wife committed to an insane asylum. He simply needed the signature of 2 doctors and a claim that his wife was suffering from moral insanity or hysteria. The step-by-step process for this maneuver was chillingly efficient. Step 1. The husband would identify symptoms of domestic rebellion and frame them as medical pathologies. If a wife was refusing to perform her domestic duties, expressing a desire for her own career, or most importantly, threatening to leave the marriage, these were not seen as rational choices. They were seen as symptoms of a diseased mind that had lost its natural feminine alignment. Step 2. The husband would summon 2 physicians, often men he knew socially or professionally. In an era where medical standards were loose, a husband's account of his wife's behavior was often the only evidence required. The doctors would observe the wife's agitation that was naturally caused by her husband's threats, and cite it as proof of her unstable condition. Step 3. The husband would sign a contract with a private asylum. These institutions were often for-profit businesses that relied on the steady stream of wealthy patients provided by desperate husbands. Once the wife was behind the gates, her legal existence was effectively terminated. A primary case study that illustrates the danger of this help is the story of Elizabeth Packard in the 1860s, whose struggle echoed through the rest of the century. Her husband, Theophilus Packard, was a clergyman who found Elizabeth's diverging religious views and her growing independence to be a threat to his domestic authority. Under the laws of Illinois at the time, a husband could commit his wife without the evidence required in other cases. He literally had her dragged from her home in front of their children and placed in the Jacksonville State Insane Asylum. She remained there for 3 years. The potential outcomes of this strategy for the husband were near perfect. He retained full control of the property, held absolute custody of the children, and avoided the public shame of a divorce trial. For Elizabeth, her only hope was to prove she was sane, a nearly impossible task when the very act of protesting her incarceration was used as further evidence of her madness. When Elizabeth Packard finally gained her freedom and took her husband to court, the trial became a sensation. It revealed the dark side of the help men were using to bypass the divorce courts. The jury eventually found her sane, and she spent the rest of her life lobbying for the Packard laws, which required a jury trial before anyone could be committed to an asylum. However, even with these new laws, the historical trend of medicalizing domestic conflict continued well into the 1890s. Men simply shifted their tactics, using the emerging field of neurology to diagnose their wives with hysteria. The specific help available to a man in this position often involved the rest cure, a treatment popularized by Dr. Silas Weir Mitchell. While presented as a medical necessity for nervous exhaustion, the rest cure was often used as a legal and social muzzle. A husband could have his wife confined to a room for weeks, forbidden from reading, writing, or speaking to anyone but her husband and a nurse. This was the ultimate form of asset protection. While the wife was in the cure, she could not sign legal documents, she could not speak to a divorce lawyer, and she could not rally her family to her side. It was a way to break her will and force her to drop any plans for a legal separation. In the eyes of the Victorian public, the husband wasn't a villain. He was a devoted, suffering spouse trying to save his poor, sick wife. The financial data from this era suggests that the cost of maintaining a wife in a private asylum was often far less than the cost of a high-society divorce settlement. A man might pay $500 a year for a premium room at a private sanitarium, whereas a divorce might cost him $50,000 in property division and a lifetime of alimony. This was a cold, calculated business decision for many men of the Gilded Age. It protected the family legacy from being carved up by the new Married Women's Property Acts, and kept the man's reputation as a stable, responsible head of household intact. However, the tide began to turn as the 19th century closed. The rise of investigative journalism, spearheaded by figures like Nellie Bly, who famously feigned insanity to expose the horrors of Blackwell's Island, began to shine a light on the abuse of the asylum system. Men who used this strategy began to face a new kind of risk: the risk of a public scandal that was far worse than a divorce. If a man was caught trying to railroad a sane wife into an asylum, he became a social pariah, viewed as a monster who had violated the most sacred duties of a protector. This shift in public sentiment forced men to move back into the courtroom, but they brought their new medicalized language with them. If they couldn't lock their wives away, they would use the claim of mental instability to ensure the wife received no money and no children in the divorce. The battle moved from the asylum gate to the witness stand, where doctors would testify about a woman's reproductive health and its impact on her moral character. This was a more subtle, but equally devastating form of help. As we move into the final years of the 1890s, the struggle for a man seeking a divorce reached a fever pitch. The asylum strategy was failing, the private detectives were being discredited, and the alimony awards were reaching record highs. Men were feeling cornered by a legal system that they felt had abandoned them in favor of a new, sentimental view of womanhood. This frustration led to the creation of the most controversial organization in the history of American divorce, the Alimony Club. What happened when men decided that they would rather go to jail than pay a single cent to their ex-wives? How did a group of wealthy New Yorkers turn a prison cell into a badge of honor and a political statement? The next part of our masterclass explores the legendary alimony war of the late 1890s, where the battle for the checkbook moved into the city jail, and the definition of a man's honor was put to the ultimate test. The revolution against the divorce courts was about to begin. The transition from the Victorian parlor to the iron bars of the Ludlow Street Jail in New York City marks the most defiant chapter in the history of 19th-century divorce. By 1898, a specific legal phenomenon had taken hold of the American imagination: the Alimony Club. This was not a social organization found in the upscale brownstones of Manhattan, but a literal brotherhood of men incarcerated for civil contempt. To understand the help a man sought in this desperate corner of the law, you must understand the weaponization of the body against the checkbook. Imagine if you are George Bennett, a middle-aged stockbroker in the year 2026, looking back at your namesake in 1899. George didn't lose his fortune to a market crash. He lost his freedom because he made a calculated, cold-blooded decision that he would rather rot in a cell than see his ex-wife spend another dollar of his hard-earned capital. In the late 1890s, the legal system had a peculiar way of enforcing alimony. If a man refused to pay, he wasn't charged with a crime in the traditional sense. He was found in contempt of court. This was a civil matter, but the punishment was physical: imprisonment until the debt was satisfied. For many men, this was the ultimate trap. However, for the members of the Alimony Club, it became a strategic bunker. Historical trends show that these men, often from the professional and upper classes, turned their incarceration into a high-stakes game of chicken. The help they were seeking was leverage. By going to jail, they were effectively cutting off the wife's income stream entirely. If the husband was in jail, he wasn't working. If he wasn't working, there was no current income to garnish. The strategy was to wait until the ex-wife, facing her own mounting legal bills and a total lack of support, was forced back to the negotiating table to accept a much smaller, one-time lump sum settlement in exchange for his release. The step-by-step process of joining this elite circle of the disgruntled was meticulously planned. Step 1 involved the strategic liquidation of accessible assets. Before the contempt hearing, a man would often transfer his property to a silent partner or bury his liquid cash in overseas accounts or private vaults. Step 2 was the courtroom defiance. The man would stand before the judge and declare a total inability to pay, even if his lifestyle suggested otherwise. When the judge issued the order of commitment, the man would surrender himself to the sheriff with a sense of grim satisfaction. Step 3 was the occupation of Alimony Row. In jails like Ludlow Street, these men weren't mixed with common thieves or violent offenders. They occupied a specific section of the prison where, for a fee, they could recreate a semblance of their former lives. Case studies from the New York press in 1899 describe a lifestyle that was jarringly comfortable. The members of the Alimony Club had their own furniture brought in. They wore their own tailored suits, smoked expensive cigars, and had meals catered from nearby restaurants. They spent their days playing cards, reading the financial papers, and discussing legal strategy with their visiting attorneys. It was a protest movement of the wealthy. They framed themselves not as deadbeat dads, but as political prisoners fighting against an unfair and predatory legal system. They argued that the alimony laws had turned them into a new class of indentured servants, and the only way to break the chains was to occupy the jail cells until the laws were changed. One particularly striking case study involves a man who spent nearly 3 years in Ludlow Street Jail over a dispute regarding a few $1,000s. He calculated that the interest on the money he had hidden away was more than the cost of his room and board in the jail. By staying incarcerated, he was actually increasing his net worth while his ex-wife was forced into poverty. This was the dark math of the alimony club. It was a war of attrition where the man used his physical endurance as a shield for his wealth. The potential outcomes of this strategy were often successful in a cruel, pragmatic sense. Many wives eventually signed releases just to end the legal nightmare, receiving pennies on the dollar of what the court had originally awarded them. However, the alimony club also served a deeper sociological purpose for the 19th century man. It provided a support network of peers who validated his anger and his sense of victimhood. In an era where the new woman was beginning to demand the vote and greater social autonomy, the alimony club was a bastion of the old patriarchal order in retreat. These men shared help, in the form of legal loopholes, names of sympathetic referees, and tactics for hiding assets from the increasingly sophisticated alimony hunters, private lawyers who specialized in tracking down the hidden wealth of divorced men. The public reaction to the alimony club was a fascinating mix of disgust and secret admiration. While many saw them as selfish cowards, a significant portion of the male population saw them as heroes of a sort. This public pressure eventually led to the alimony law of 1899 in New York, which sought to limit the time a man could be held for civil contempt. Before this law, a man could theoretically be held for life if he never paid. The new law limited the stay to 3 months for small amounts and 6 months for larger debts. Paradoxically, this change in the law actually helped the men more than the women. Now a man could go to jail, serve a predefined sentence of 6 months, and emerge with his debt wiped clean in the eyes of the law, though his credit and reputation might be in tatters. For the man in 1899, the help provided by the alimony club was the ultimate nuclear option. It was the final rejection of a domestic contract that he felt had been unfairly rewritten by the state. But as the clock ticked toward the midnight of the century, even this defiance began to lose its edge. The legal system was evolving again. Judges were becoming wise to the empty pockets defense and were beginning to use the power of the court to seize property directly from third parties, bypassing the husband's refusal altogether. The era of the gentleman prisoner was coming to an end, replaced by a more aggressive bureaucratic form of financial enforcement. But the alimony club was just the surface of a much deeper cultural resentment. As the 19th century drew to a close, men were realizing that the legal tools of the past, the asylums, the private detectives, and the jail cells, were no longer enough to maintain their status. A new kind of masculinity was being forged in the fires of the divorce courts, one that was cynical, guarded, and increasingly organized. The final battle of the century wasn't being fought in the jails, but in the halls of the state legislatures where the very definition of marriage was being debated. What happened when the states tried to pass a uniform divorce law that would have stripped men of their divorce colony loopholes? How did the rise of the progressive era threaten to turn every man's home into a transparent box under the supervision of social workers and government agents? And most importantly, what was the great escape that thousands of men took as the new century dawned, leaving behind their lives, their debts, and their names to start over in the wild, unregulated West? The conclusion of our masterclass takes us to the edge of the 20th century, where the 19th century man made his final, most radical move for freedom. The blueprint for the modern divorce was finally complete, but the cost was a total reimagining of what it meant to be a husband in America. The end of the Victorian era was not a whimper, but a roar of legal and social defiance that still echoes in our courtrooms today. As the sun began to set on the 19th century, the ultimate form of help for a man trapped in an impossible marriage was no longer found in a New York courtroom or a Philadelphia law office. It was found on the tracks of the Northwestern Railway, heading toward the horizon. This was the era of the Great Escape, a historical trend where the vast, unregulated expanse of the American West became the final legal loophole for the desperate. Imagine if you are William Anderson, a clerk in a dusty Boston accounting firm in the year 2026, looking through the digitized census records of 1899. You see your great-great-grandfather listed in April with a wife and 4 children. By October, he has vanished from the East Coast entirely, reappearing 2 years later in a mining town in Nevada with a new name, a new wife, and a completely different history. This was not a rare occurrence. It was a systematic response to the rigid, punitive divorce laws of the Atlantic states. The help a man sought in the West was built on a foundation of legal jurisdictional arbitrage. While the East Coast was tightening its moral belt, Western territories like South Dakota, Wyoming, and Nevada were competing for divorce tourists to boost their local economies. The most famous of these was the Sioux Falls divorce colony. To understand the step-by-step process of this Western cure, you have to look at the residency requirements. In New York, a man might wait years for a decree, but in South Dakota in the 1890s, the residency requirement was a mere 90 days. A man would take a business trip or a health retreat, check into a luxury hotel in Sioux Falls, and wait out his 3 months. Step 1 of this process was the establishment of a bona fide intent to remain. This was the legal fiction upon which the entire industry rested. A man's lawyer in Sioux Falls would advise him to do more than just sit in a hotel lobby. He would be told to open a local bank account, register to vote, and perhaps even purchase a small, inexpensive plot of land. These were not intended as permanent investments. They were physical evidence to be presented to a judge to prove that the man was now a citizen of the West. Step 2 involved the filing of the petition under liberated grounds. Unlike the East, which often required proof of adultery, Western courts began to recognize extreme cruelty, or neglect of duty, in a much broader sense. A man could argue that his wife's constant nagging or her refusal to follow him to the frontier constituted a form of mental cruelty that made his life intolerable. Case studies from the Sioux Falls era show that this became a booming industrial sector. The city built high-end hotels specifically to cater to wealthy Easterners who were waiting out their residency. These men would spend their days hunting, fishing, and socializing with other colonists, forming an informal fraternity of the soon-to-be single. The potential outcomes of this strategy were almost always favorable. Because the wife was usually thousands of miles away in the East, she often could not afford the travel or the legal fees to contest the suit in a South Dakota court. This resulted in a default judgment, granting the man his freedom in record time. However, this help came with a massive shadow risk. When these men returned to the East with their Western decrees, they often found that their home states refused to recognize the divorce. This led to the infamous interstate divorce wars, where a man could be legally single in Reno but a bigamist in Rochester. For the man who didn't have the money for a hotel in Sioux Falls, the help was even more radical: the total erasure of identity. In the late 1800s, there were no social security numbers, no national databases, and no way to track a man across state lines once he changed his name. This was known as "GT gone to Texas," or simply heading for the tall timber. A man would liquidate his personal belongings, take his wages in cash, and board a train. By the time he reached the frontier, he would adopt a new surname and a new backstory. Historical trends show that this informal divorce was the primary way working-class men handled domestic failure. They simply resigned from their lives. The data from the 1900 census reveals a staggering number of widowers in Western towns who were, in reality, husbands who had simply walked away. But as the 19th century transitioned into the progressive era, a new and more intrusive form of help emerged from the government itself. This was the rise of the social welfare machine. Reformers, concerned by the sheer number of abandoned families, began to push for the uniform divorce law. They wanted to close the Western loopholes and create a national standard that would make it impossible for a man to outrun his domestic obligations. This movement introduced the first wave of what we now recognize as the domestic relations court. These were not traditional courtrooms. They were overseen by social workers and experts who believed that a man's domestic life should be a matter of public record and scientific management. For the man of 1899, this was a terrifying shift. The help being offered by the state was now rehabilitation. If a man was failing in his marriage, the court wouldn't just grant a divorce. It would send a friendly visitor to his home to inspect his habits, his spending, and his sobriety. This was the beginning of the end for the private domestic sphere. The historical trend was moving away from the husband as the absolute king of his castle, and toward the husband as a ward of the state, whose performance as a provider was under constant surveillance. Case studies of these early domestic courts in cities like Chicago show that men were being ordered to attend counseling or face jail time long before these concepts became mainstream in the 21st century. The conflict between the Western escape and the progressive surveillance created a unique tension. Men were caught between an old world that was disappearing and a new world that wanted to track their every move. To navigate this, the 19th century man had to become a legal ghost or a social performer. He either had to play the part of the reformed husband perfectly to satisfy the new social workers, or he had to vanish so completely that the law could never find him. This was the high-stakes reality of help at the turn of the century. It wasn't about finding a middle ground. It was about choosing which system would own your future. As we look at the final years of this era, we see the birth of the modern legal defense. Lawyers began to use procedural help, finding tiny errors in the filing of the marriage license or the service of the summons to have cases thrown out on technicalities rather than on the merits of the marriage itself. This was the beginning of litigious divorce, where the goal was no longer to prove who was right, but to see who could stay in the game the longest. The 19th century ended with a society that was more divorced than ever, yet more obsessed with the sanctity of the home than ever before. The help for men had evolved from the absolute rights of the 1820s to the elaborate spy games of the 1890s, and finally to the radical escapes of 1900. But there is one final piece to this puzzle. What happened when the law finally caught up? What was the grand finale of the 19th century divorce era that set the stage for everything we see in the year 2026? In our final part, we are going to look at the landmark case that changed the definition of marriage in America forever, and the secret legacy that every man in the courtroom today is still living with, whether he knows it or not. The curtain is about to fall on the Victorian era, and the modern world is waiting in the wings with a whole new set of rules. The year is 1900, and the American legal system is standing on the precipice of a revolution that will define the next 100 years of domestic life. To understand the final evolution of help for men in this era, we must look at the legal earthquake that occurred just after the turn of the century, the landmark Supreme Court case of Haddock versus Haddock in 1906. This case serves as the ultimate historical trendsetter for how interstate divorce would be handled in the modern era. Imagine if you are Mark Thompson, a digital architect in the year 2026, looking at a dusty leather-bound volume of legal precedents. You might find it hard to believe that a man's entire life could be undone by the simple act of crossing a state line, but in 1906 that was exactly the risk. The Haddock case involved a husband who left New York, established a residency in Connecticut, and obtained what he believed was a perfectly legal divorce. He remarried and lived his life for nearly 20 years, only to have his first wife sue him in a New York court for alimony. The Supreme Court eventually ruled that because New York did not have jurisdiction over the wife, it did not have to recognize the Connecticut divorce. This created a legal nightmare of potential outcomes. A man could be legally divorced in one state but still legally married, and liable for decades of back alimony in another. The help a man needed at this moment shifted from simple litigation to a complex understanding of the full faith and credit clause of the Constitution. Step one for a man in this era was no longer just getting the decree. It was ensuring the decree was bulletproof against future challenges. Lawyers began advising men to use the personal service strategy. Instead of relying on a notice in a small-town newspaper, a man would hire a process server to physically hand the divorce papers to his wife in her home state. This was a high-stakes move. If she accepted the papers, she was technically acknowledging the jurisdiction of the foreign court. If she ignored them, she was doing so at her own peril. This historical trend marked the transition from secret divorces to adversarial divorces, where the goal was to force the other party into a legal cage they could not escape. By 1900, the data from the United States Census showed that divorce rates had increased by 15-fold since the Civil War. This was not because marriages were becoming more miserable, but because the help available to men had become more standardized. We see the rise of the professionalized family lawyer. In the 1840s, a man might hire his business attorney to handle a separation. By 1900, he was hiring a specialist who understood the specific idiosyncrasies of every judge in the county. These specialists developed the collusion playbook. Recognizing that the fault-based system was a relic of a bygone era, lawyers for both the husband and wife would meet in private clubs, far from the eyes of the court, to script the entire trial. The step-by-step process of a collusive divorce was a masterpiece of Victorian theater. Step 1. The husband would provide evidence of a minor fault, such as a single night spent in a boarding house under a false name, or a series of letters suggesting a coldness toward his wife. Step 2. The wife would file the suit based on this manufactured evidence. Step 3. The husband would fail to provide a defense. By 1900, over 90% of divorces were uncontested. This was the era of the uncontested lie, where the legal system and the participants engaged in a mutual fantasy to achieve a pragmatic goal. This historical trend laid the groundwork for the no-fault laws that would eventually emerge 70 years later, proving that the law often follows the reality of human behavior, rather than leading it. However, for the man who could not afford a luxury divorce in Sioux Falls or a scripted trial in New York, the help of 1900 looked very different. This was the era of the poor man's divorce, which was essentially a form of high-stakes vanishing. Case studies from the early 1900s show a massive spike in what was called interstate desertion. A man would walk out of his home in Ohio and reappear in the booming oil fields of Oklahoma or the timber camps of Washington. Because there was no centralized federal tracking system, these men were effectively starting their lives from scratch. They were not just changing their addresses, they were changing their identities. This was a radical form of asset protection. If the court could not find the man, it could not garnish his wages. This created a social crisis that led to the creation of the first Desertion Bureau in 1905, an early precursor to the modern Child Support Enforcement Agency. The financial reality for a man in 1900 was also being reshaped by the rise of the companionate marriage movement. For the first time, courts were starting to look at marriage not just as a property contract, but as an emotional partnership. This sounds like progress, but for the 19th century man it was a double-edged sword. It meant that his failure to provide emotional satisfaction could now be used as a ground for divorce under the umbrella of mental cruelty. To fight this, men began to use the economic provider defense with renewed vigor. A man's lawyer would bring in bank ledgers, property deeds, and grocery receipts to prove that even if he was emotionally distant, he was a perfect provider. In the eyes of many conservative judges of 1900, a man who kept a roof over his family's head and stayed out of the saloons had fulfilled his part of the contract. As we look at the legacy of this era from our vantage point in 2026, we see that the 19th century struggle for divorce help was really a struggle for the definition of masculinity itself. The men of the 1820s were masters of their domain, shielded by the law of coverture. The men of the 1890s were legal gladiators, navigating a minefield of detectives, asylums, and alimony jails. This transition transformed the American man from a sovereign head of household into a contractual partner subject to the oversight of the state. The help they sought was always a reaction to the shrinking of their traditional power. The final piece of the 19th century puzzle was the Uniform Divorce Movement. In 1906, President Theodore Roosevelt called for a national Congress to standardize divorce laws across all states. He feared that the divorce mills of the West and the scandalous trials of the East were destroying the American family. While this movement failed to pass a federal law, it succeeded in making migratory divorce much more difficult. It forced men to stay and fight in their home jurisdictions, leading to the birth of the modern high-conflict domestic trial. The 19th century ended not with a resolution, but with a stalemate. Men had lost their absolute dominance, but they had gained a new set of tactical tools, detectives, asset hiding schemes, and jurisdictional loopholes that would define the 20th century courtroom. The help was no longer about asserting a right. It was about managing a risk. As the Victorian era closed, the American man was left standing in a courtroom that looked remarkably like the one we see today. A place of high emotions, massive financial stakes, and a legal language that often obscures the human reality of a broken home. But the story of the American domestic battleground didn't stop in 1900. Just as the rules of the 19th century were written in the blood and ink of the Industrial Revolution, the rules of the 20th century were about to be rewritten by the rise of the modern woman, the explosion of the Jazz Age social norms, and the technological revolution of the private eye. What happened when the silent detectives of the 1890s traded their notebooks for wiretaps and high-speed cameras? How did the alimony club of the 1890s evolve into the political lobby groups of the 1920s? And most importantly, what hidden 19th century laws are still being used against men in the year 2026 without them even realizing it? The next chapter of our masterclass will dive into the Roaring Twenties and the first great boom of the modern divorce industry, where the stakes went from thousands of dollars to millions, and the Great Escape moved from the frontier to the silver screen. The battle was just getting started.